Post-judgment matter. The matter was adjourned from July 9th, 2024, so that the defendant could produce documentation showing that the motor vehicle, a certain Jeep, had been paid off and the lien satisfied. This hearing is being conducted via Zoom. Present is Attorney Leah Worker representing the plaintiff, Maria Wyatt. Ms. Wyatt is present. Is Kevin Wyatt present on audio? It appears that he is not. Mr. Worker, did your client reach out to Mr. Wyatt, remind him of the court hearing today?
Your Honor, we've not had any contact with Mr. Wyatt. Do know that he was aware of the hearing. I had sent him communication on July 25th and have not received any response or communication from him.
Right, texting him, calling him to let him know that the court's waiting for him?
No, Your Honor, we have not. I sent him an
email.
email.
You, Ms. Worka, can you?
Oh, I'm sorry.
I didn't ask, I asked, can you? If you said Ms. Wyatt doesn't want to call him, I don't know if there's a restraining order in place. If she can't be contacted, can you call him and just see if you leave him a voicemail, let him know the court's waiting for him? Maybe he simply forgot.
Certainly, Your Honor.
Thank you. Ms. Brown, thank you for your help this morning. I know things got a little hectic, but thank you.
You're welcome, Your Honor.
We were short and we had things that were stacked on top of the other.
Your Honor, I called the telephone number that I have for him and left a voicemail.
Okay. All right. The court has received a fine recommendation this morning. So, Ms. Worker, you obviously received nothing from Mr. Wyatt in terms of documentation showing that the lien on the Jeep has been satisfied?
I received some documentation from Mr. Wyatt showing that the Jeep lien has not been satisfied.
Okay. Why would he send you information that's not satisfied when he represented that it was?
Well, prior to us filing the show cause, he had represented that it was paid off. It became apparent that it was not based on comments that he had made. He, I believe, admitted when we were in court last that it had not been paid off, despite him withholding the money from my client's settlement. He had sent some information regarding the payment history of the Jeep, which I responded there was a discrepancy in that information. But the documentation he sent me indicates that there is a balance owed on that vehicle.
And we don't know where the title is that correct?
We do not. I believe that Mr. Wyatt had indicated that he did not have it, or if he did have it, he didn't know that he had it. But it's not in my client's possession.
And there was no discussion about the title to that Jeep when this judgment divorce was entered. Is that correct?
I don't believe specifically it was awarded to Ms. Wyatt. We did reach that agreement through mediation.
Yes, the plaintiff, Maria, was awarded that Jeep. And defendant was to make the payments for October, November, December, and plaintiff make the payments from January 2024 forward. So she's currently making those payments. Is that correct, Ms. Worka?
No, she has not. She had not been provided with the information or the authorization to do so from Mr. Wyatt.
Right. The recommendation this afternoon is that defendant shall pay plaintiff the remaining settlement of $21,183.49, cooperate with obtaining title to the Jeep, execute the necessary documents to allow plaintiff to communicate with the credit union regarding the loan, and authorize the credit union to release the lien to plaintiff upon paying the loan in full. I think what the court should do also, Ms. Brower, if we can put in language, maybe even somewhere, the court can order that Mr. Wyatt personally appear, and if he fails to appear, the court can issue a bench warrant for his arrest. This order, he's can ignore it, and we're back to step one. Maybe Ms. Worker, to get his attention, maybe rather than ordering all these particulars, maybe the court simply note that he's failed to appear today, order him to personally appear. We'll give a specific date, and then the order can say that's fair to appear result in issuance of bench warrant. Hopefully that'll get his attention. Any objection to that? I want to get this. We need to bring some matter to some closure, and that's perhaps the best way to get Mr. Wyatt's attention.
I would agree, Your Honor. My client's frustrated. She's been trying to resolve this matter without success. I would expect, or at least hope, that would result in getting Mr. Wyatt's attention.
So, Ms. Brower, I wonder if there's a last line that's blank. Maybe you can type in capital letters or bold language. Defendant Kevin Wyatt shall personally appear before Judge Bronlick, and we'll give you a date. And then we can put a semicolon fair to appear result issue. It's a bench warrant, just so that he is well aware. Do we have time in a couple of weeks? 28th then.
No, the 21st, I can do it 2:30.
About the 21st on August 21st. I'm sorry, 2:30 on August 21st, Ms. Worka?
That should work for me, Your Honor, yes.
So the court will order, it will add to this recommendation of the Apostlemus per hour that the defendant shall personally appear on August 21st, personally appear before Judge Brownick, August 21st, 2024, 2:30 p.m. Period fair to appear will result in issuance of bench warrant for arrest. Hopefully that language can be prominent on this order so that you can clearly see that. And right now there's a restraining order. Ms. White has no contact with Mr. Wyatt. Is that correct?
Your Honor, there's not a restraining order, but Mr. Wyatt's communication with my client has been aggressive and abusive, and so she does not have contact with him.
Okay. All right. If he calls you back, Ms. Worka, perhaps suggest to him that he's got to take care of these matters, because if he fails to appear the next review date, bench warrant can issue for his arrest.
I certainly will, Your Honor.
Hopefully that will prod him to take action, get this done. And your client has no idea who the lender is on this automobile?
She knows the name of the lender, and she's had that information, but because she's not listed anywhere on the account or on the loan, they won't communicate with her or give her any information. She had attempted to just make a payment of a random amount, and then we believe that Mr. Wyatt then canceled that payment that she made.
Okay. Well, hopefully the Jeep's not going to, who's in possession of the Jeep right now? Ms. Wyatt?
My client is in possession of the vehicle, yes.
Well, hopefully it's not getting repossessed, Ms. Wyatt.
We certainly hope so as well, Your Honor.
I don't know why they would refuse to take a payment from a third party, Ms. Worka. Maybe you can intervene and talk with the lender. I mean, I don't know why they would turn away money.
The credit union accepted and began processing the payment. Our understanding, based on a text message from Mr. Wyatt to my client, was that he canceled the payment, alleging he didn't know who had attempted to make the payment.
How can he cancel someone's check? Why can't Ms. White just mail a check to the credit union or take a check in there?
Your Honor, I don't know the details. I know that the funds from that payment were, my client indicates they were withdrawn from her account and not returned, but I do not see that payment applied to that loan based on the screenshots that Mr. Wyatt provided to me.
Well, perhaps you can get involved, Ms. Rook. I can't imagine a financial institution turning away a payment that someone's making. A parent making a payment on behalf of a child, I mean, they're going to take it if you have a loan number. But I'm just suggesting that to maybe get involved, because I hate to see that vehicle repossessed out of from Ms. Wyatt's driveway. Again, obviously, the longer the payments are made, she's going to be paying more interest. She's awarded the Jeep. It's going to be an additional cost to her. So maybe they can approach other ways. But in any event, hopefully, unfortunately, that's the best I can do is a month from now. So we'll order Mr. Wyatt to personally appear August 21st, 2:30. If he fails to appear, but court will issue bench warrant at that time. Anything further?
No, Your Honor, we are requesting attorney's fees.
Good. Let's see what he does.
Certainly. Thank you, Judge.